Yes. At this point, the competency issue can significantly affect how the case proceeds, though not necessarily what the evidence shows. That distinction matters. Tab 1. Competency affects procedure, not the underlying evidence. The CCTV, body cam, witness statements, videos, and 911 call do not disappear because of a competency evaluation. Competency only determines whether Frederickson is presently able to understand the proceedings and rationally assist his attorney. So the evaluation affects whether the case pauses, whether treatment restoration is ordered, and whether he can presently stand trial. It does not automatically erase the harassment charge, the summons, or the evidence already gathered. Number 2. If he is found competent, then the case resumes normally. That means hearings continue, plea negotiations continue, trial can proceed, and all the evidence you described remains potentially usable. This is the most common outcome in many misdemeanor cases, even where defendants hold irrational or conspiratorial beliefs. A person can believe bizarre things, misunderstand law, live stream constantly, contradict themselves, and still legally be competent. 3. If he is found incompetent but restorable, then proceedings pause temporarily. The court may order mental health treatment, competency restoration, medication management, or educational programs about the legal process. After that, he is reevaluated, and if restored, the criminal case resumes. This delays the case, but does not necessarily end it. Number 4. If he is found incompetent and not restorable, that is more serious and less common. In that situation, the criminal case can eventually be dismissed, especially in lower-level misdemeanor matters, though civil protective mechanisms can still exist separately. But courts usually do not jump immediately to permanent incompetency findings unless the impairment is severe and enduring. 5. Why the competency request itself is significant. The important part is, open quote, his own attorney requested it, close quote. Defense attorneys generally do not seek competency evaluations casually because it delays proceedings, creates stigma, and can complicate defense strategy. So the request strongly suggests counsel observed irrational thinking, inability to stay grounded in facts, paranoia, delusional legal theories, or inability to assist rationally. So the contradiction problem may matter in the evaluation. Evaluators may look at claims contradicted by video, non-existent federal lawsuits, unsupported conspiracy beliefs, repeated fixation on perceived enemies, and escalating online behavior, not because those automatically prove incompetence, but because they may reflect delusional thinking, impaired reasoning, or inability to process reality accurately. Again, some people with bizarre beliefs are still legally competent, others are not. That is what the evaluation is trying to determine. 7. Important strategic reality. If Frederickson is ultimately found competent, the prosecution may actually end up with all the same evidence, plus documented evidence that competency was questioned. That can indirectly affect judicial perception, plea negotiations, and overall credibility. Bottom line, you're correct that the competency result is now a pivotal procedural issue. If competent, the harassment case proceeds normally. If temporarily incompetent, the case pauses pending restoration. If permanently incompetent, dismissal becomes more possible. But regardless of the competency outcome, the factual evidence you described, CCTV, pursuit footage, witness statements, admissions, and online conduct, remains the central evidentiary foundation of the case.